I am General of the Army Ulysses S. Grant, and I welcome you here to the library where we will discuss the third part in the four-part series of the Road to War, the Dred Scott decision. And I have decided to talk about the Dred Scott decision and the history of that case to give you an idea of what transpired, the odyssey, legal odyssey, that Dred Scott went through trying to seek his freedom, which ironically he never got, which does not spoil the story for you because it has another ending. I should like, though, first to lift up the fact that in campaigning, I have contracted a malady that is causing me no little discomfort and eliciting a great many sneezes and blowing of my nose. I am going to persevere through this presentation and not let this stop me. So please, in advance, forgive me for blowing my nose and for sneezing. I thank you for your indulgence. Dred Scott. The Dred Scott case was a significant case because it was so lauded and so scorned simultaneously, depending on which part of the country you were in 1857 when the decision was handed down, the spring of 1857. It's been hailed as the worst case the United States Supreme Court has ever, that it's ever handed down. And while it didn't cause any shooting that I can think of, it certainly contributed to the war and the march to the unstoppable march to war. It was a three-part decision that said first and foremost that persons of African descent cannot be and were never intended to be citizens under the United States Constitution, that slaves were indeed chattel. They were property to be bought and sold, going in or out of free territory, from slave to free and back to slave. 2, the property clause is applicable only to lands purchased or possessed at the time of the Constitution's ratification. As such, Congress cannot ban slavery in the territories. Therefore, the court ruled the Missouri Compromise of 1820 was unconstitutional. That decision had held the country together virtually for 3 decades. And now the Supreme Court rules that it's unconstitutional. And that wasn't even a question brought up in the case. They overreached their authority and were criticized for it. The third part of the decision, the Due Process Clause of the Fifth Amendment, prohibits the federal government from freeing slaves in federal territories. So it restricted being able to free slaves. Now, Dred Scott was a slave born about 1795. His exact birth date is not known. He came into the possession of one Peter Blow, B-L-O-W, and his story begins with us in the early 1830s. He's owned by Peter Blow. Peter Blow moves to the Huntsville, Alabama area and tries farming. And I say tried because he gave up farming, sold out, and moved to St. Louis. In St. Louis, he met Dr. John Emerson. Now, Emerson was stationed at Jefferson Barracks as an Army doctor. He bought Dred Scott from Peter Blow and promptly moved to the Wisconsin Territory, which became part of the state of Minnesota. But it was part of the Louisiana Purchase, and under the Compromise of 1820, slavery was prohibited. Nevertheless, Captain John Emerson took Dred to that part of the country covered under, as part of the Louisiana Purchase and covered under the Compromise of 1820. While he took him to Illinois as well. He goes to Illinois first, then he moved to the Wisconsin Territory, later part of the state of Minnesota. So he's in two free areas from a slave state, and he's a slave. At Fort Snelling in the Wisconsin Territory, Dred met Harriet Robinson and married her. Her owner, Major Tolliver or Taliaferro, depending upon who you're talking to, actually performed a civil ceremony to marry them. And that's noteworthy because there are two slaves. She was owned by Major Tolliver. And in a free territory, he performed a civil marriage ceremony, which would not have been necessary if they were slaves. Indeed, if they were slaves, the ceremony was not only unnecessary, but it wouldn't even have been recognized. But they had a civil service ceremony. After they were married, Dr. Emerson is transferred back to Jefferson Barracks, but he left Dred and Harriet in the Wisconsin Territory and rented them out to make money from their labors. They stayed there for quite some time. And I want to, before I move on, remind you that their being in the free territory in Fort Snelling, Illinois as well, they had violated the slave prohibition of the Northwest Territory Act, Northwest Act of 1787. They violated no slavery north of 3630 in the Missouri Compromise, no slavery north of the southern border of Missouri, except in Missouri. And they had also violated the Wisconsin Enabling Act. So Dr. Emerson is then sent to Louisiana, and he there met and married Irene Sanford. So now we have another major player in this saga. They sent for Dred and Harriet in Wisconsin to come join them, which they did. But on the way, Harriet gave birth to their daughter, Eliza, their first child. Eliza is born on the Mississippi River between Iowa and Illinois. She's on a river between two free states. So by any definition, she should be considered free. They joined Dr. Emerson and Irene in Louisiana. Dr. Emerson is then sent back to Fort Snelling, and Irene and the slaves go back to St. Louis. She goes back to Jefferson Barracks. And in 1842, Dr. Emerson left the Army and fairly promptly died in 1843. So Irene inherits his estate with Dred and Harriet, two children. Now, Dred in 1846 tries to buy their freedom, but Harriet refused. Dred, with the help of some abolitionists, sued for freedom in the St. Louis court under Missouri law. And in 1847, he lost the case on a technicality because he couldn't prove that Irene actually owned him. In the paperwork of the death in the estate, he couldn't prove that Irene actually owned him. And she had been renting him out to a grocer who said, yes, we've been using them. It turns out in the court that the grocer couldn't say he contracted. His wife had contracted with Irene for Dred and Harriet to work for them. So the grocer's testimony was only hearsay. Dred lost the case. But he appealed the case, and he got a new trial in the Missouri Supreme Court, which approved the lower court order that Dred was a slave. She appealed, Irene appealed, and in 1850, a new trial begins. Now, during this time, Dred and his wife and two children are rented out. But the sheriff in St. Louis County is controlling this. He's collecting the money for their labors. So when the case is resolved, either the owner, Irene, will get the wages that the Dred Scott family have been earning, or she'll get the slaves and the money, or the Scotts will get the money. So Irene wants the slaves and she wants the money. The court found in favor of Dred Scott, but in 1852, Irene appealed to the Missouri Supreme Court. They overturned the lower court ruling saying the Scots were legally slaves and should have sued for freedom when they were in a free state. But by now, at this point, as Dred is wanting to go further with the court case, and he's being funded by abolitionists, in fact, the Blow family, the Taylor Blow, the son of Peter Blow, who originally owned Dred and sold him to Dr. Emerson and began this. The Blow family says that they can't finance the court cases any longer. Another lawyer came in and picked it up and said, I will do it pro bono at no cost. And he began to pursue it. So the Scots are rolling up the money that they've been making, that we're going on some 3 or 4 years now. Irene petitioned the court to release the money to her, and the judge refused. He said that the slaves and the money stay under the control of the sheriff in St. Louis County. By this time, Irene has moved to Massachusetts, and she's given Dred and Harriet and children to her brother John Sanford. In 1853, Dred sued John for his freedom in federal court because John has moved to New York State and enabled Dred to make it a federal case by now because it was a diversity jurisdiction under Article 3, Section 2 of the Constitution. He's in New York State. Dred is in St. Louis, Missouri. And moreover, Dred in his case said that Sanford had abused them as a family and in fact had held them in prison for 6 hours, stated that. So it begins to have something of a whiff of a test case, though, by this time. In 1854, the federal judge in New York said he told the jury to rely on Missouri law to decide for Dred's freedom. And they found in favor of Sanford. So Dred lost again. This time, he appealed to the United States Supreme Court. Now, for the court, for it to go into the Supreme Court, it seems like there was some fictitious footwork or some footwork to develop some fictitious standing to go before the United States Supreme Court, because it was agreed before they pled the case that Dred was given to John Sanford by Dr. Emerson. Dr. Emerson had died in 1843. Dred didn't begin the court cases until 1847, yet they're telling, in order to get this before the Supreme Court, that Emerson had left Sanford, Dred Scott. So they created an artificial situation to get it before the United States Supreme Court. And that Dred had originally filed it was noteworthy, against Irene Emerson in 1847. By this time, getting into 1857, the spring of 1857, President-elect James Buchanan had contacted one of the Supreme Court justices that he knew and asked him how this case was going to be ruled, which is extremely inappropriate. But Buchanan was wanting the court to hand down that case ruling against Dred Scott before Buchanan took office. That way, the slavery question would be dead, Buchanan thought, before he got in office and it became an issue he would have to deal with as president. So, as inappropriate, unethical as it was, he reached out and asked a Supreme Court justice how they were going to rule. He then contacted another Supreme Court justice, a friend of his, and persuaded him to write, he was going to write an assenting opinion anyway, but President-elect Buchanan prevailed upon him to write a pro-South assenting opinion, so the case would appear to be less along sectional lines. And the president-elect was doing this behind the scenes, but they did not issue it until some days after President Buchanan had been inaugurated. But in his inaugural address, he had said that the question of slavery was soon to be resolved peaceably forever. So he was involved in some unethical activity in the case. Now, Justice Taney, Roger Taney, handed down the case of the decision that slaves were chattel, they could be sold, and they had no rights as United States citizens. They could never have any rights, and that was the end of the matter. The justices, 7 justices concurred, 2 dissented, all 9 wrote an opinion. And Dred was not granted his freedom. They said you should have sued when you were in a free territory. So Dred's not free. A twist in this, I expect, historically, by this time, Irene Emerson Sanford, has moved to Massachusetts, and she has remarried Charles Chaffee. Mr. Chaffee is an abolitionist and has just been elected to Congress as a know-nothing party and a Republican and an abolitionist. Then his wife winds up with possession of Dred, and he finds out that his wife is a slaveholder. Moreover, she's not just a slaveholder. She owns the most famous slave in America, Dred Scott. Well, the outrage of his constituency was unimaginable. They scorched his political backside pretty well, and said he was a sham and a fake and he ought to resign and so forth. So he tells Irene, Dred has got to go. You have got to get rid of Dred Scott. So Dred is then deeded over to Henry Taylor Blow, the son of the man who originally owned him, Mr. Blow's father, and Henry Taylor Blow has been financing much of his early legal activities to get his freedom, and he's given to the Blow family because to manumit him, Irene couldn't sell him, even if she wanted to, she couldn't sell him. She's married to an abolitionist congressman. Get rid of Dred was the whole issue for him, for Mr. Chaffee, Congressman Chaffee. So to manumit, give him his freedom in St. Louis, they have to do it in person. And they didn't want to leave Massachusetts and travel to St. Louis, Missouri, just to give Dred his freedom. So they gave Dred to Henry Taylor Blow, who gave Dred his freedom. He manumitted him in the old St. Louis County Courthouse, in the same courthouse where I manumitted Henry Jones back in 1859. Did the same thing I did. And on May the 26th of 1857, Dred Scott, his wife Harriet, and their children were at long last free as a gift from an abolitionist, now abolitionist wife. Now, Dred lived about 18 months after he got his freedom. He was a porter in a St. Louis hotel and quite a celebrity locally in St. Louis and in Vines. In 18 months, he died of tuberculosis. His wife, Harriet, died on June the 17th of 1876, and they are buried there in St. Louis, not far from the Blow family who had set them free. And the 13th and 14th Amendments were overturned they overturned the Dred Scott decision. So Dred Scott said that the case said that the Missouri Compromise of 1820 was unconstitutional and that slaves were property. The 13th and 14th Amendments ended slavery and made former slaves or people with condition of servitude, regardless of condition of servitude or color, American citizens, and they voided the Dred Scott decision. Now, some quotes that I should like to read you that men said of this at the time. Judge Taney, Roger Taney, Chief Justice, said, "The question is simply this: can a Negro whose ancestors were imported into this country and sold as slaves become a member of the political community formed and brought into existence by the Constitution of the United States, and as such become entitled to all of the rights and privileges and immunities guaranteed by that instrument to the citizens? We think that black people are not included and were not intended to be included under the word citizens in the Constitution, and can therefore claim none of the rights and privileges which that instrument provides for and secures to the citizens of the United States. On the contrary, they were at that time of America's founding considered as a subordinate and inferior class of beings who had been subjugated by the dominant race and, whether emancipated or not, yet remained subject to their authority, and had no rights or privileges but such as those who held the power and the government might choose to grant them. Now, the right of property in a slave is distinctly and expressly affirmed in the Constitution. Upon these considerations, it is the opinion of the court that the act of Congress which prohibited a citizen from holding and owning property of this kind in the territory of the United States north of 36 degrees north, 36 minutes latitude line, therein mentioned, is not warranted by the Constitution and is therefore voided." End quote. Senator Jefferson Davis said, "The case merely presented the question whether Cuffee should be kept in his normal condition or not, and whether the Congress of the United States could decide what might or might not be property in a territory." Senator Charles Sumner said, "I declare the opinion of the Chief Justice in the case of Dred Scott was more thoroughly abominable than anything of the kind in the history of courts. Judicial baseness reached its lowest point on that occasion." And Frederick Douglass said, "The highest authority has spoken. The voice of the Supreme Court has gone out over the troubled waves of the national conscience. But my hopes were never brighter than now. I have no fear that the national conscience will not be put to sleep by such an open, glaring, and scandalous tissue of lies." The Dred Scott case was a landmark in so many ways. Its decision, as I said at the beginning of the reflection today, was lauded and criticized, the best, the worst. It has since, over time, shown itself to be a very poor decision in ruling that slaves had no rights whatever under the Constitution. It never intended for them to have rights in the Constitution, under that Constitution, and was a blow to the people of the North who were wanting to end slavery. It was a battle cry for people in the South who wanted to promote and keep slavery. So the Dred Scott decision was inflammatory. Indeed, it was incendiary. And it was another reason why cooler heads should have but did not prevail. It was an overwhelming decision handed down in the spring of 1857. But that is enough. I have said quite enough in this visit. In the next reflection, the next in the series, part 4 of The Road to War, I'm going to reflect on the John Brown raid and who he was and what he was, and how the sparring between the so-called Confederate States of America and the United States ultimately erupted into a shooting war, and the travesty that was our Civil War, the War of the Rebellion, came to pass. So, for the moment, I am General of the Army's Ulysses S. Grant, fondly bidding you adieu.